So it's wonderful that you are taking advantage. I know that some of the students here are in high school, some are community college students, but we also have a number of students who are both. They're doing high school right now, but they're dually enrolled, and they're also AWC students, and so they're going to graduate from college before they graduate from high school, which is kind of strange, but neat at the same time. All right, I would like to thank a few people because bringing you all together here today is not something that happens without the participation and the assistance of a lot of people. So first of all, I'd like to thank Arizona Western College, April Hale, Nicole Parr, and Brenda Doak, Professor Doak, have been instrumental in getting us to this point. So I want to thank them for hosting us, and also the President's Office, President Dr. Daniel Kaur. Thank you so much for having us. I'd like to thank Jessica Holzer of the Yuma County Bar Association. She is the attorney who is the president of the Local Attorneys Organization. Also, Amy Wood of the Arizona Court of Appeals. She's our clerk of court. Tracy Randall of our court, as well as Carlos Solano, who does IT. And you really don't think about IT too much. I thought IT just kind of fixed your printers, but as it turns out, we depend on them greatly. I'd like to thank you for attending. We have Yuma Catholic, we have Kofa High School, Hill Ridge, and Somerton. Give me the name again of the school? Somerton High School. So thank you so much. We also have from our trial court, from the Superior Court, we have our presiding judge, Judge David Hawes. We have Judge Eliza Johnson. We have Kathy Shaven, Court Administrator. She is. And Nancy Gray-Eid, Deputy Court Administrator. Let's see. We want to especially thank counsel, the attorneys representing the parties, for coming out. They've been gracious to agree or not object to presenting their cases here, and we are delighted to have them. I want you to know that this case, that the arguments that you're going to hear today are not something that we have sort of hand-selected, you know, this is the case that high school students should hear. This is the regular business of the court. We talked to AWC about what day would work to have this event, and then we looked at our calendar, what's on the calendar for that day, and this is the case that was on calendar. So you're going to see an actual case being litigated in front of you. So I'd like to thank attorneys Dennis Willencheck for being here, Edwin Stanley, Lawrence Pallas, and Mitchell Antalis. So thank you so much for being here. So as I mentioned to your advisors and your teachers, the way we're going to proceed is that we're going to hear oral argument. The judges will come in, they will gavel in. When the gavel bangs, you will rise as we do in court. The judges will take the bench. Argument will commence. When that ends, our panel of judges is going to exit the room, and you will have an opportunity for a few minutes to ask questions of the attorneys. And you can ask them questions about the case. They can answer or not answer. It's up to them. And you can ask them questions about their career path. Again, it's up to them. The attorneys are representing the parties, but they are not employees of the court. We do not control them. So we thank them for participating. After that, the judges will come back out, and they will also answer questions, but they will not answer questions about the case because the case will then be under advisement, and they don't discuss it until the decision is issued, which could be a couple of days or longer, depending on where they are in terms of agreement. And then after that, hopefully we'll also have the opportunity to have you interact with some of our law clerks who are here today, and law clerks are persons who have recently graduated from law school. They work with the court for a year or two. They help us do research and write drafts, and they participate in our conferences, presenting cases and answering questions of the judges. So they are they're closer in time to where you are in terms of education than maybe someone like me. So it's always really interesting to be able to speak with them and as to their experience. And I have two of them. Two of my clerks are here at the clerk table. All right, so with that, I believe we are ready. Are we ready for the judges? So let's go ahead and get started. Please silence your electronics, your cell phones and any other electronics you may have, so that the proceedings are not interrupted. Thank you.
Good morning. This is the time set for oral argument in our case number CACB 230699, Todd Borowsky versus Mark Brooks et al. Each side is allocated 20 minutes for oral argument. Appellant, you may reserve a portion of your time for rebuttal if you wish to do so. If you wish to do so, you need to keep track of your own time using a somewhat different timing system that we have in place today. Now, out of respect for counsel and to avoid any embarrassment, let me ask that everyone in attendance make sure if they have a cell phone that those are disabled so we don't have any ringing noises that would interrupt the proceedings. We have read the briefs. We've conferenced the case. We'd encourage you to keep that in mind as you present oral argument to us today. Our proceedings are being recorded and will be posted to YouTube. So please, as you begin your argument, state your name and the party that you represent. With that, Mr. Wilenchek, you may proceed.
Thank you, Your Honor. May it please the court. Dennis Wilenchek for Todd Borowsky. I have to start by making sure this thing works here. Can everybody hear me?
We can hear you
Okay.
well. And if that changes, we'll let you know.
Thank you. I have to also say I'm a little disappointed because I thought it was our great advocacy that caused the court to select this case, and now I find out it was just a random selection. So that's a little disappointing, but let me also say, while I'm on it, what's disappointing also is here I thought that it was my great advocacy that caused the verdict, but apparently the lower court believed otherwise, believed that it was something else. So let me start by saying that it is clear that the hallmark of our democracy and our judicial system rests with the jury system that we all cherish and honor. And absent a most cogent reason, the case law is clear to me that jury verdicts should be deferred to and upheld. And I urge this court in this case to do just that. We're talking about a case, and I'll try to use some of the lower court's words as well, that went on for 4 years, 13 days of a jury trial, resulted in the second largest verdict of a jury that year in 2022. The jury sat through that trial. The jury heard all of the evidence, and it was extensive evidence about Mr. Brooks's, quote, credibility. And the judge, I believe, wrongfully took that away from the jury at the end. After denying mistrials in the case itself, which he could have granted, and then awarding $250,000 after trial in doing so against my client in attorney's fees. Now, basically, for the benefit of all, there are two, what I'll call fleeting comments that the judge used primarily to make this ruling. And essentially, they relate to Mr. Brooks's prior history of felonies in the plural, 4 felonies, that the court knew, as you know, were 4 felonies from our motions in limine. The court emphasized, however, that there was 1 felony which is clearly erroneous, and it had to do with his ruling substantially because he emphasized it in his ruling that Mr. Borowsky was lying on the witness stand, and therefore he felt it was deliberate, knowing misconduct to try to harm Mr. Brooks's credibility. But Mr. Brooks's credibility was destroyed by Mr. Brooks himself, not by his past and not by these fleeting comments. There was extensive evidence on cross-examination, which I conducted, which proved without any doubt to this jury the nature of his malicious conduct in getting my client arrested and lying about a payment on a loan that caused him, because of personal reasons, to go after Mr. Borowsky at his home, set it up with a SWAT team in the night, lie to the police about it, get my client arrested, who spent 6 months in jail worrying, as he testified, every day, and then ultimately beat up, his shoulder dislocated forever.
Mr. Wilenchek, let me ask you just a couple of kind of definitional sort of things. You were trial counsel, but is that correct?
I was trial counsel.
But the sanction was imposed against your client alone. There was no suggestion. I see nothing in the briefs.
Absolutely nothing. And in fact, worse, counsel, to their credit, acknowledged that there was no attorney misconduct at all.
And one of the things I'll want counsel to address is whether that matters with respect to the standards that we've been cited.
Under Levy, yeah.
Yeah, and other cases.
Yeah.
But you focused to start on Mr. Brooks's felony convictions, which were subject to what are called motions in limine,
That's correct, Your
pretrial
Honor.
motions, and the court said no, that can't come in.
Correct.
Yet Mr. Borowsky testified about his prior felony history.
Yes.
But wasn't there other misconduct that the trial court relied on? That wasn't the only thing. It didn't strike me as...
To answer you honestly, I think the answer is no. I think what the court did was the court said there are other instances, but based on those instances, I would never have granted a mistrial. However, he said, and I think that's what you're alluding to, that, cumulatively, I think he said, I won't be quoted, but something to that effect, that it added to the most serious things, which were, in his judgment, as I said, the lying about the multiple felonies. And then, in a strange ruling, I think, I don't mean any disrespect to the court by saying that, but in a ruling that I don't understand, quite frankly, based on how it went down, he found a comment about, I think, a daughter of Mr. Brooks, Alexis. My client made some reference to her being a front for her father, who could not get a license based on his prior criminal record. Mr. Borowsky believed that saying criminal record, for what it's worth, was not saying felony. I don't know that that's correct or not, but I think it goes to the knowing and deliberate aspect. But in any event, the real reason the court granted on that issue had to do with the front man, which clearly he had stated without objection. It came up after a sidebar, and the judge allowed my client to answer, who was not privy to the sidebar. And we all knew that he was going to say that she was a front man. There was no question about it. And the objection was to foundation. It wasn't to the prejudice. And no mistrial was even granted. Again, the court had the opportunity, and I think this is critical, to grant mistrials during the trial. And the court specifically considered that and did not do so based on the two instances that we believe people heard. The first instance, I think everybody conceded, was not heard.
And the court did not, you're absolutely right, grant a mistrial during trial.
And that was at the beginning of the trial.
No, I know, but instead, the court let things sort of work their way through.
Yes.
and see how it worked out. Wouldn't the trial judge have been subject to criticism for jumping the gun if a mistrial was granted before that happened?
No, I think in fairness, the answer is no. If he felt that this was going to credibility and he felt that it was a serious infraction, I believe he would have saved us $250,000 in fees and a lot of money being spent on our side trying this case and a lot of heartache by granting the mistrial if he felt it was material. Now to answer your question directly, I think it's even worse that he did it after for this reason. Again, causing all of that damage to occur and then awarding it against us, what he based his ruling on, to answer your question, was based upon simply the size of the verdicts. I've read that order. I cannot find any basis for him doing so after the fact, other than, as you say, the verdict that turned out. And he felt—
Counsel, if I could just interrupt
Sure.
for a moment, and to get to something that Judge Thema had pointed out earlier, although you're focusing on the quote unquote fleeting comments, it is true that the Superior Court noted that Borowsky's violations of the orders in limine were not limited to Brooks' prior felony conviction, and then the court goes on to detail the additional misconduct that it based its order on, which suggests to me, sort of in response to the mistrial issue and your concern that it was only those comments, that the court had to see the breadth of the repeated misconduct before it could reach its conclusion. Isn't that a more fair read of the Superior Court's minute entry?
it may be to the court, but not to me. I was there, and I can tell you that there was no substantial, important, essential issues, to use the Levy language,
Well,
that had
counsel,
to do with any of that. And the court even stated
I
that if it
appreciate-
had been
counsel.
just those kind of comments, the court would never have granted a new trial, because they weren't substantial, they weren't important, they weren't essential, and they didn't really
counsel,
didn't
that's
do
me.
anything. I'm sorry.
Is it your call on whether it's substantial or the Superior Court's call that we give deference to? It seems to me we give deference to the Superior Court's call on that one.
Well, you have to give deference based on what it's based on, and that's what I'm addressing.
And the
Can't
court
be based in a
identified,
vacuum.
no wait, the court identified, basically there were dozens of violations throughout
Dozens?
the trial. And the court said that when you add them all up at the end of the trial, it was cumulative.
I don't know about dozens, Your Honor. I don't know where that would come from. I know exactly what statements were made.
Well, I think we've looked at the record, and I'm not going to go through them all with you, but I don't think the court was wrong on that.
I don't remember him saying dozens, but if he did, I'll defer to you.
No, I'm saying the dozens.
Well, there weren't dozens, is what I'm trying
Okay.
to say. And there were a few other remarks, and they were very minor. For example, one of them, as I recall, was Mr. Borowsky, the court claimed— I did not see it, but the court claimed was making certain facial gestures or something. Assuming that to be a basis to call him out on it, he did. He also called him out on all the other statements and told the jury to disregard them, to strike them, and I believe, to get to your question, that the court should have also presumed that the jury, again, the sacred jury who made their decision, would have had the ability to listen to the court and make those determinations for itself.
He also went through all the motions in limine and the rulings and what your client could and could not say. And following that direct admonition outside the presence of the jury, your client did it some more. Disagree?
Which statement are you referring to, Your Honor?
That your client continued to make statements in violation of the motions in limine even after the court's direct admonition.
I think the only other statement made, I'll get back to it, has to do with Alexis Brooks after the first statement, I'll call it, about the felonies which offended the court. And then there was a dialogue about Alexis Brooks where he stated that because of his criminal record, he could not have the license, and she was the front man. And it was the front man argument that I believe, in fairness, the judge was offended by, which was not subject to a motion in limine. So I disagree factually with what you're saying. I don't think there was any substantial misconduct. And if there was, the court repeatedly, if anything, was very harsh on my client in that court, made it very clear to him and to the jury that comments are not allowed, and told the jury to disregard them, to strike them. And I believe the jury should be deferred to that they did that. And I don't think that the judgment in any way reflects any passion or prejudice, because that judgment deals with emotional damage, psychological damage, and such injuries that were never objected to in any instruction. Even when the jury came back and asked questions about the formula for the damages, nobody spoke up. And finally, in terms of any inconsistent award, nobody spoke up then while the jury was impaneled and could have corrected anything that was now believed to be either inconsistent or excessive. So the jury was given—
Let me ask, does the not failure, but a decision not to follow a motion of remitter, does that prevent us from considering the size of the award of the trial court? Because I don't think one was offered.
I'm not following you, Judge. Their failure to—
They didn't move for remitter. and to produce the award, the verdict. And so, does that in any way affect the analysis that we give to considering the amount of the award?
I think it does, yes. I think there's no ability to question that at this point at all. And they didn't file an appeal on that, of course. We filed a motion to retrial. We filed an appeal. They did not appeal that. They did not preserve that, is my point, under Rule, whatever it is, 49, I believe. And you have to do that. The case law we cited is clear. I won't waste time on that. But it is absolutely essential that if you're going to complain about such things, going to the nature of the verdict itself, whether it's inconsistent, excessive, et cetera, you have to do so with the jury there and give them the ability to correct that. And this was something that was discussed. It's not something that wasn't discussed. It was discussed, you'll see in the record, and they chose to waive it. And they did not object to the instructions. They did not object when the jury came back and asked questions. So I believe the amount of the verdict itself cannot be used for the basis of showing prejudice. I don't believe the Levy case is an appropriate case because of factors dealing with attorney misconduct, which the cases that cite it make clear, where an attorney has a certain obligation ethically to not deliberately mislead a jury, clearly.
Counsel, let me ask you on that point, because that is a primary point in your opening brief. Rule 59 talks about misconduct of a party.
Yes.
And the cases, for the most part, deal with misconduct of counsel as opposed to misconduct of a party. Levy is a great example. But why should the standard be different?
As I say, I think if you look at the 6 cases that I found citing Levy in particular, there are other cases dealing with new trial that deal with other kinds of misconduct. Sure. But the specific cases that Levy deals with, I think, are very specific as to attorney misconduct. And if you read those cases, and I'm sure you have, but for the benefit of everyone, they're cases that specifically deal with deliberate attorney knowing misconduct that are barred by our profession, by our code of ethics. And that's very important. And therefore, the kind of serious, deliberate misconduct led by an attorney is very important in those cases. And generally speaking, a witness, and in this case, I don't believe the court had the ability, and I with all due respect to Judge Gass, I don't believe the court had the ability to judge that this had any effect after 13 days on a verdict based on substantial evidence that I can go into of lying, of deliberate misconduct by the opposing Mr. Brooks and the others who set Mr. Borowsky up to be arrested, who was ultimately harmed by that.
And I understand your point on that, but the rule contemplates a new trial based on, I'll quote, misconduct of the ellipsis prevailing party.
Yeah.
What standard would you advocate different than Levy for party misconduct as opposed to lawyer misconduct?
Good question. I do think that some of it does overlap. I think if it were shown that this conduct was so harmful and it could be shown, and the standard to show it is different under Levy, it puts the burden on me to show it as opposed to the other side. If the other side and or the court could really show, and I know it's difficult to show, the case law makes that clear too, but if they could show that this verdict was completely off the wall based on passion or prejudice, given some questions the jury sent in or something else, given the fact that they were so far away from the instructions. But the problem in this case is the instructions led the jury to do exactly what they did. There can be a total verdict. They can allocate that verdict however they wish under case law. The instructions allow them to do that, and they questioned that.
Let me ask you on the passion or prejudice, because that's another independent ground under the rule for a new trial. What then would be left, if that's the standard, to misconduct of the prevailing party? It seems like that text needs to do more work.
Well, let me make my point clear if I didn't before,
Sure.
so everybody's understanding it. I believe that the court had in front of it, when the instances came up, and it was a violation of the motion in limine, had the right to grant a mistrial. The court had that right. I would never have objected if the court had done that or done anything about it. We would have mistried the case and retried it at the beginning. It would have been okay with me in reality. But the court could have done that based upon whatever factor of prejudice, given the motion in limine, the court felt that that kind of a statement made before the jury continued to hear the rest of the evidence. That could be presumed. But once the jury heard 13 more or 12 at least more days and a half of evidence and made its findings, deliberately asked questions, showed that they were responsible, the jury verdict in this country should be sacrosanct in my judgment.
But
And it could only be overturned on the most, like I said, cogent of reasons that are where there's not substantial evidence to support the verdict. And here,
do you have any authority, counsel, that says because somebody made a motion for mistrial, the court can't revisit that issue afterwards in a motion for new trial?
no, I didn't say that, Judge, and I agree with you.
Okay, thank you.
Yeah, no, I'm not saying the court couldn't do it. The court has discretion. But our position is it's an injustice and an abuse of discretion under the case law to have let it go on, knowing that there's no other comments made, knowing the jury was carefully paying attention, asking questions, even after the deliberation, that there's substantial evidence, which the court completely ignored in my judgment, all of the evidence that absolutely convincingly proved that this was a setup, it was a planned attack, it was purposeful lying. We had a tape recording. We had numerous people, including one of the defendants, Mr. Johnson, admit that it was a lie ultimately. This was serious misconduct that went on that the judge just ignored the jury's verdict on for his perception that the verdict, quote, made no sense. But it does make sense. It makes all the sense in the world if you were there listening to the evidence. This was a horrible set of facts for the defendants. It was not a close call under Levy, not at all. And the court would be in error to find it was, looking at the substantial weight of the evidence, which is why the court couldn't find for them on the JMOL, the judgment that was filed afterwards based on lack of substantial evidence. I didn't realize the time had run down, and I apologize. Can I reserve a minute?
You may. We'll give you
Thank
2
you.
minutes in rebuttal. Mr. Willinchuk, before you sit down,
Yeah.
we had asked for briefing on appellate jurisdiction. I read the briefs as kind of agreeing that we have appellate jurisdiction. Do you
I think it's clear, Your Honor. I'm not sure why the court had a problem with that Maria case, given it.
I take the case as I find it. So,
I could go on. Thank you.
Thank you.
Appreciate it.
Thank you. We look to counsel for defendants. We have 3 people. Tell us how you're going to divide your time, or if one person will speak for all, that's just fine. But you have 20 minutes collectively.
Thank you, Your Honor. I'm Edwin B. Stanley. I'm counsel for Mr. Brooks. We've agreed that I'm going to take most of the laboring oar on this argument, probably 12 minutes or so, and then
It is your time to allocate as you wish.
Defer to my
It's just
colleagues.
you need to keep track of that. And if you could speak right into that microphone, I sure would appreciate it.
is that better, Your Honor?
It is.
Thank
And
you.
let me start with the jurisdictional question. Is there any dispute that this court has appellate jurisdiction?
Not from our side, Your Honor.
Very
I think
well.
the court has jurisdiction.
Thank you. Please proceed.
Mr. Willinchuk started his argument with the proposition, which I agree with, that the jury system in our system of law is very important, and it's the hallmark of what we do. But for the jury system to work, people have to follow the rules that are set up. And for our guests, that's a whole semester at least in law school of learning the rules of civil procedure and how to follow those and how to present evidence to a court. I'll submit that Mr. Borowsky violated many, many, many of those rules and traditions that we have. And as we review the record in this case, you can see the frustration of the trial court in trying to make this case into something that would be something that the jury could fairly consider. And at the end of it all, the court, in its discretion and properly executed and exercised, found that all of those times of cheating by Mr. Borowsky made this trial into something that it shouldn't be. And that's one that delivers substantial justice to all of the parties. And that is clearly not what we had here. Now, the record reflects that Mr. Borowsky continually, throughout this trial, violated the orders in limine. He refused to abide by court admonitions and instructions to answer questions that are not voluntary and not voluntary things that aren't responsive to questions that are asked of him. not commenting in front of the jury about the testimony of other witnesses, and generally being disruptive throughout the entire trial. And the court, after an extensive analysis of the authorities that this court has laid down for us, actually the Supreme Court in Levy, said this verdict can't stand, and went through, I think that minute entry is 20 pages long, of all the things that Mr. Borowsky did, and how those affected the ultimate verdict, at least presumptively. Now, there is no presumption.
Mr. Stanley, I was going to ask just a point of clarification. The sole ground for the mistrial was misconduct by Mr. Borowsky alone, right? There's no
Yes.
allegation of counsel misconduct. Now, that may distinguish some cases, and we should probably talk about that, but it's his conduct in open court while court was in session that caused the mistrial.
Yes, Your Honor. And I'll address the issues that was brought up with Mr. Willinchek. Does it matter if it's the lawyer or the party? And the rule makes no distinction between the two. And I'll submit, Judge, it doesn't matter, and there shouldn't be different standards, because the issue to focus on is there a prejudice to your average juror? And jurors are just people, and they're people who have no legal background for the most part. And so the court has to look at it from that lens. And so it really doesn't matter if it's a lawyer who violates a motion in limine or doesn't conduct himself appropriately, or if it's the party or herself, because
Although
that
if
information.
If it's a lawyer with their license to practice law, that could be subject to discipline. That's one distinction.
Sure.
But you're saying what happens in the courtroom is the same whether it's lawyer or client.
Yes, Your Honor, because
And
the question.
What's your best authority to support that proposition, that it should be the same standard? And then I want to get to Judge Perkins, who was patient with letting me ask you.
Well, as the court noted, there are the vast majority of the cases that interpret Rule 59 on this misconduct issue deal with the misconduct of counsel. And so to the extent that it's actually the party, which is pretty rare, I'll admit, those cases support it. And off the top of my head, Judge, I'm not able to direct the court to the exact cases that are in our papers. But again, the issue is, how does it affect substantial justice? And if it's coming out of the lawyer's mouth or the party's mouth, it really doesn't matter, because it can have the same impact upon the jurors. And I'll also say, Judge, that at the beginning of cases, jurors are instructed that the arguments of counsel are not evidence. They are not instructed as to what witnesses say and parties say. And so to that extent, I think that when it's the misconduct of a party, it's even more egregious than it's the misconduct of a lawyer. Judge, did you have a question too?
2 points that Mr. Willinchek made that I think would be helpful to touch on. There were maybe a couple of different jumping off points before the new trial motion, one of them being the mistrial request. And another that I think Mr. Willinchek raised, I think we'd like to hear from you on, is that there was no request from the defendants, no minute or no challenge to the verdict as inconsistent or excessive. Could you speak about those?
Yes, Judge. I think that what the Superior Court did here, although Mr. Willinchek says today, a couple of years later, I wouldn't have objected to a mistrial motion. I think we would be here in front of you arguing a mistrial, potentially, although I'm not sure that the court would have jurisdiction over that, but they would have certainly complained about that. And it's not uncommon in cases like this to let it play out and see if the party engaging in misconduct prevails at trial. Because as the court's aware, there's a lot of prep and time and headaches and late nights and coffee that goes into putting a case together. And to get halfway through and said, well, it's a mistrial, let's do it all again in a year. And we actually discussed that, it's in the record, where one of the issues that the Superior Court said was, if you want this much time, it's going to be a year and a half. And so that's a real Hobson's choice for any litigant. Do we want substantial justice, and the old chestnut, justice delayed is justice denied? Do we want to wait another 18 months, or do we want to just see how this works, knowing that Rule 59 is not dependent upon the making of a mistrial motion in the middle of the trial? Also say that this misconduct went all the way through the trial, and it's, as the cases all tell us, it's cumulative. And when there's cumulative misconduct, it just builds up and builds up and builds up. And I think the jury awards that were rendered in this case really, as the court noted, show that they were, in all likelihood, the result of passion and prejudice against my client. The other question was about Rule 49D, I think. And I don't see any references to 49D in their opening brief. That was briefed in the court below, and it really...
Indulge me anyway. It's something I'm curious about.
Well, we're not taking the position here, Judge, that there should have been a remitter or that we've waived it, because what we're pointing to these awards as are evidence of the prejudice. And we can always say there was prejudice, and here's some hooks the court can hang its hat on in finding the prejudice, which is exactly what the court did when it went through in great detail as to how these awards and these verdicts don't line up with the law and show that the jury was using the compensatory awards punitively against my client. And there's many, many issues of that, like the whole issue of that the court referred to as the UCC claims, where there was an award of, I think, $2.7 million for wrongfully repossessing cars that there was no evidence of the value of them, but they were purchased for about 10% of that. So you repossess a car, and for the compensatory value of those cars, you get 10 times the amount of their probable value as a compensatory award. That simply shows that what the jury was doing was punishing my client instead of compensating Mr. Borowsky. And when the court is looking for some evidence of prejudice against my client, that's a pretty strong one. Did I address the court's question?
Carry on.
Counsel,
Yes, you are.
there's been reference to close case. And how does close case play into this? Almost like it's a statutory requirement that it be a close case. Does it need to be a close case? And what do we do if it's not a close case?
Well, Judge, the whole concept of a close case, I have difficulty with that phraseology because
But
it can
it is in
mean...
the court cases, so we got to wrestle.
Yeah, it's in there. And it's a difficult concept to get our heads around because what's a close case to one might not be a close case to another. And there's no real definition of what that is. And from what my research has shown, there's no cases that say, yes, this party committed all kinds of misconduct, but it wasn't a close case. And so I think what we have to do is look to the prior rulings of the Superior Court, where the court found, and this was noted in the minute entry and also in the denial of motions for summary judgment, that this case was a thicket of factual disputes, and it was going to be very dependent upon the credibility of the witnesses. The unfortunate thing there is you can say that about almost any case, and you don't have a 13-day trial over a case that didn't close. So I think just the fact that it's a 13-day trial.
Do we owe the trial court deference on that decision on close case, or is it ours to look at, we don't think it's a close case?
I think the court here must defer to the Superior Court on that because the Superior Court was there. And one thing that we know is that reading things in black and white don't really tell the whole issue. And the reason that we have live trials and live juries is they see people. They see their affect, they see their demeanor, how loud did they say a particular thing? Did they pause? I mean, one thing that's not clear in any written record is, did he have to pause 5 seconds before he said it was a red light, not a green light? That it gets picked up by the court and by the judge who's presiding over the case, and can certainly tell that a party is being hesitant or not. So I think that that is a thing that we need to defer to the Superior Court on, because the Superior Court is there and sees all the things that the jury sees and is much more able to determine, gee, is witness A or witness B more believable based upon all the things that we rely upon a jury to determine in hearing live testimony.
So I know you're going to hand this off to some other folks, but what about the fact that it was a new trial in all counts, as opposed to just some, like, for example, related to your client and the comments about the felonies, but that the judge decided to do it as to all?
These claims all arise out of the same set of operative facts. And to try to parse that out and leave some and grant a new trial on some, one, I think that would be an impossible bit of surgery for any judge to do. And the fact that all of the claims were so dependent upon competing theories of the facts. And the salient facts are not that much in dispute. There's loans, there's repossessions, Mr. Borowsky was in jail. The real meat of the case was why did they do this, and what did they do, and was it their fault, all those things. And those all came down to credibility of the witnesses. And so to try to parse out, I hope I'm responding to the court's question.
You are, and I was just going to do a follow-up. So the challenge here, especially with credibility of the witnesses, is if you inappropriately or violate a rule and impugn one, that the mud from that splashes on everybody. Is that a fair analogy?
Yes, Judge, and I think my colleagues are going to be addressing that. But take Mr. Johnson. The majority of the claims against him were for aiding, abetting, and conspiracy to do all the things that they said Mr. Brooks did. And to, not grant him a new trial when his purported co-conspirator is tainted by this improper evidence, I think that would be a disservice to him.
And is that part of the challenge with the cumulativeness of what ends up being about $18 million in total in judgments? And when you put them all together, especially a co-conspirator getting hit independently?
Yes, I think so, Judge. I think what that shows is, since there was cumulative awards on all of these things that build upon themselves, they really build upon the credibility of that side of the room as opposed to that side of the room. I've got 5 minutes left. I'll defer to my counsel unless the court has additional thoughts or questions.
No,
thank you.
Good morning, Your Honors. If it pleases the court, I'm Lawrence Pallas on behalf of Robert Johnson. I will also probably be carrying some of the water from Ms. Pate, as she's also really a secondary alleged tortfeasor here. I'd like to start with this issue of whether this was a close case or not. And I think that the Superior Court's order quotes Judge Martin's order. And I could assure you that the briefing was comprehensive on summary judgment. And what he had to say was, you can't tease this all apart. This is, and there aren't really that many disputed facts about what happened that day and at a couple of hearings. What's in dispute are the conclusions that are drawn from people's purported actions, and what were their motivations, and what was it that what was their intention, and that's what's in dispute. And if you sling mud improperly and you introduce a bunch of inadmissible prior bad act evidence and the felony or felonies, then all of a sudden what is really a close case becomes the kind of case where you have a runaway verdict like this. And I don't think that you can judge whether or not it's a close case based on the verdict after the offending party has cheated the whole time. and then look back and say, well, look, we won. It wasn't a close case. I mean, I think you have to really look at what the case was before the offending conduct occurred. The entire case here rises and falls for all of the defendants on whether or not Mark Brooks whether the appellant was in breach of the loans and whether Mr. Brooks had the right to repossess these vehicles. And if the answer is that he was in default and that the attempt to repossess these vehicles was a legitimate lawful action, then everything falls. All of these claims go away. And as counsel pointed out, the claims against Mr. Johnson, 10 of 14, more than 2/3, are for derivative liability. He conspired to do this thing, or he aided and abetted it. And incidentally, there are also the substantive claims against him, and perversely, he ends up with more liability, not necessarily in terms of dollars, but in terms of claims, because there's this added aiding and abetting claim when you can't aid and abet yourself. So you either commit the tort or you help commit it. You can't really do both. But if the claims against Mr. Brooks are tainted, then it must follow that all of the derivative claims for conspiring to do it or assisting in doing it are tainted as well. How do you tease that apart?
But what about the ones that aren't derivative?
Well, they're tainted for the same reason, because whether or not he trespassed, whether or not there is a violation of the UCC, the breach of the peace, whether or not there was malicious prosecution because of the alleged lies at the hearing, it all rises and falls on whether or not this was a legitimate repossession or not, or attempt to repossess. And so the whole thing is tainted. And that's really on the liability. Incidentally, I'll point out, Mr. Johnson, there is no admissible evidence of his involvement or knowledge about the repossession until an hour before it occurs. And we have a case where Mr. Borowsky is constantly forcing the parties to move to strike, get those, the improper testimony stricken, and you, of course, presume that the jury follows the court's instruction. But how many times before it is no longer reasonable to make that presumption? And when you're talking about dozens of times, and they all clearly sort of surround the business dealings between Mr. Johnson and Mr. Brooks, and the jury's wondering, what is it they're hiding from us? And what happened is that Mr. Borowsky supplied him an answer. And this is direct prejudice, and this is all in the order. He says that
You may finish your thought.
thank you. He says that they tried to do this to me before. I paid back a loan. Brooks tried to keep my collateral, and it was Johnson with Millennium Bank. He says that Johnson's his front man because he can't get licenses with the pawn shops. He says that Johnson and Brooks tried to buy his pawn shop out from under him. And most importantly, he says that they've been doing these bad loans and stealing property from people. And so there's no presumption required for the prejudice to Mr. Johnson. He drew him a map. And this is really, it tracks the motion in limine and the prior motion for a protective order right through, and he introduces all of the very evidence that he was precluded from introducing.
Counsel, thank you. Time
Thank you.
goes fast. Mr. Willinchek, 2 minutes in rebuttal.
I'll go quickly with the limited time. First of all, there were bases for the statements that were just made by Mr. Borowsky. Secondly, if you refer to page 6 of our reply brief, we list the non-derivative claims that were found. Next.
So should we treat those non-derivative claims differently?
No, I'm just saying that if they're making the argument that everything is tied in, there were separate claims that the jury found against them that had nothing to do with derivative claims.
So should we treat them differently if we
Yeah,
decide that?
yes.
And why?
Because they're independent claims. They have nothing to do with the allegations against Mr. Brooks that they claimed that my client made. If this was a runaway verdict, they should have utilized Rule 49 at the time and not now. There were repeated documented lies that we don't have the time to go into, that our briefs go into. that would take me literally half an hour to go into, that the jury relied on over the 13 days, and cross-examination, I think, in days of Mr. Brooks that showed him to be a liar. Judge Martin didn't say it was a closed case, and I believe we should defer to the jury on a closed case, given what they were saying, not the court's conclusions. But the court's conclusions, to be clear about this before I sit down, were completely belied by the case law. The wacky case, WACQI, that we cite to in other cases, the court cannot presume prejudice based on the size of the award. And that is all the court did, is complain about the size of the award and so forth. That is not a basis to presume prejudice under the case law, and the court has no other basis to do so, because the jury made the right decision. And believe me, if you go through that record, I appreciate if you did, you'll see for all those 13 days all the various lies and inconsistencies they told and problems with their case that the jury heard clearly. This was a clear case, not a close case. And the court could not make a case to show that this was close at all. The jury made the right decision, and the jury, the people, should be heard, not the court's conclusions after the fact that he had the opportunity to grant a mistrial for, and specifically chose that it wasn't serious enough or prejudicial enough to not do so. To do so after, based on the size of the award alone, is completely violative of Arizona law, and that's a fact. I thank you. Unless you have questions.
We do not.
Thank
Thank you,
you.
counsel. We appreciate your presentation today. We appreciate your briefing as well. You've given us much to think about. We'll take the matter under advisement. We'll issue a written ruling in due course. Now that the court formal session has ended, I do want to make a couple of comments. We appreciate counsel traveling to Yuma to share your wares with the students and the others in attendance. That's a meaningful thing. We try to take the court to the people, because it's not our court, it's the people's court in every real sense. Mr. Willinchek, you indicated at the beginning of your arguments that this case was not selected specifically. That may be the case, but it wasn't excluded, and there are certain types of cases that we would never have brought to a public presentation at the school, and I appreciate that. But thank you. It's a hardship for you, and we appreciate you doing that. Thank you all also for Arizona Western College and the students in attendance. This is and others in attendance, the officials who were kind enough to come here. It's a big undertaking, and we appreciate it. We hope that you learn from it. It is your court just as much as it is ours, and that's a meaningful thing to us, and I hope it's meaningful to you. Now, we're going to leave for a little while and let you talk to the attorneys and ask them all the questions that you have, and we may get a little time to talk to you later. But we appreciate you all so much for being here today. The court's in recess.
We do you, Your Honor.
As usual, it was fun.
Thank you. You may be seated. I hope you have enjoyed the presentation. I want to piggyback on something Judge Thama said at